This is Werner Sabo. I'm a construction attorney and architect in Chicago. I'm also an arbitrator and mediator. In these videos, I discuss arbitration and mediation topics. I'd like to talk about the mediation process and what it is and so forth. So there's many different types of mediations. There are providers that provide trained mediators, such as American Arbitration Association, JAMS, End Dispute, and so on. There are a lot of attorneys throughout the country that provide private mediation services. Now, mediations can mean many different things for many different situations. For instance, in family law, divorce situations, there are trained mediators that specialize in that area. There are many situations in court. If you file a lawsuit, the courts may well mandate that you attempt mediation before the case proceeds further on, because the judges really, they can't hear every case that comes before them, so they basically try to resolve the cases by sending it out to mediation. And many times the judges will also be the mediator, so they may give you half an hour. Sometimes it's called a pretrial, and especially in federal court, they will have the magistrate sit down with the parties and try to reach some kind of a settlement before the case moves along too far. So if you have a construction dispute, the situation is often a little bit different. Construction disputes can be very technical, they can be very complicated, they involve issues that are comprised of many different pieces, many different claims might if you put them all together, that's the claim of one party or the other. And there are often counterclaims involved. So construction cases are really best served by a mediator that understands construction. And so that's where it's very useful to go through an American Arbitration Association, JAMS, End Dispute. They have mediators that are knowledgeable about construction. So what is mediation? It's an attempt to settle the case. It doesn't result in an award like in arbitration, and it doesn't result in a judgment like a court case. A mediation results, hopefully, in a settlement where the parties agree to the outcome and they'll sign some sort of settlement agreement, and that ends the dispute, that ends the case. So mediation is a very powerful tool to resolve disputes. The mediator is typically somebody very experienced in construction, has a lot of training in most cases in that area. And for instance, the American Arbitration Association, they have a panel of trained mediators that are required to go through annual training to keep their skills sharp and to inform them of sort of new developments and techniques and that sort of thing. And the idea is to try to get the parties to come together at the end of this process and come to a settlement. There are mediations in international disputes, some of them involving construction. So there's a whole wide range of mediations that are available under different circumstances. But what I'm going to be concentrating on are construction disputes and mediation in construction disputes. So many construction contracts require mediation as a condition precedent to the next step of arbitration or litigation. So for instance, the American Institute of Architects has a series of standard agreements between various parties to the construction process. And all of them require mediation as a condition precedent. Many other form contracts also do, and privately written contracts generally will require mediation as a step before you go on to that final step of resolution. The idea behind that is if you get into a dispute, you really want to get out of that dispute as quickly and as inexpensively as possible. And mediation is the answer to that in most cases. Mediations, I find, have a very high success rate. If the parties come into the mediation anticipating a settlement, wanting a settlement, then the success rate can be 80-90%, somewhere in that range. Now, in some cases, the parties are really so mad at each other that they're really not interested in mediating. They just want to get the other side and get their pound of flesh. And so mediation, they just want to check off that box and say that they've complied with the contract requirement. And in that case, the success rate drops quite a bit. But it's still, sometimes to my surprise, in that situation, I can get the parties to reach a settlement. And I know that happens to other mediators also. So it's always worth a shot at mediation. It's very inexpensive compared to the alternative, and it's much quicker. So if you have a dispute in a construction context, you should always attempt to mediate. So you've got a construction dispute. Maybe you're the owner, you've got a dispute with the general. Maybe you're the architect and you've got a dispute with your engineer, or any other combination of disputes that you might have. So what do you do? I would suggest one of the first steps is you retain an attorney that is familiar with ADR, alternative dispute resolution processes. And that includes not just mediation, but arbitration also. And that attorney should be familiar with litigation, arbitration, and mediation. So that attorney really, the first thing to do is obviously talk to the client, interview to see what is this dispute about, what's at issue, what are the main documents, and get a hold of the contract. And the contract is really one of the first places to start. What does the contract say about dispute resolution? Probably that contract will, first of all, say that you have to mediate before you can move on. There's probably a procedure for claims. So certainly in the American Institute of Architects contract, there's a fairly sophisticated claims process that has time limits for submitting claims, where the claims go, who decides, and stuff like that. So you need to look at all of that and decide what is necessary to get this process going. The contract probably is also going to tell you who administers the mediation. Now, occasionally, especially on sophisticated projects, you may have the contract with a dispute review board or dispute resolution committee or something where there's already one or more people, mediators and arbitrators, that are already predefined, that are already in place. So that makes life a little bit easier. You just, you contact them and you get the process going that way. But normally on most projects, the AIA contract, for instance, will say that the mediation is going to be administered by the American Arbitration Association. So you would go online and they have forms that you fill out and you describe generally who the parties are, nature of dispute, and that sort of thing. You fill that out, you can do it online, and you submit that. And the claim then goes to the other side also. Now, You can, if your attorney is talking to the other attorney, which is often the case in a construction dispute, you may reach some sort of agreement on who the mediator should be. So even though you're going through AAA, you can say, I want Sally Smith as our mediator because we're confident in her ability and whatever reason you might have. So you can ask AAA to appoint that person. And again, that makes life a lot easier if you've done that. Now, if you don't have anybody in mind or if you can't agree, then AAA will send out a list of potential mediators. And you will get a list with names and biographies, and you and your attorney then will go through that list and decide, I don't like this person, or I don't like what's on his resume. I do like these other people. So you can cross off names, but generally what you would do is to order these people in order of preference. This is my first choice, this is my second choice, my third choice, and so on. And what AAA then will do is to line up these two lists, your list and the other side's list, and does sort of a numerical calculation as to who ranks highest on the combined lists. And that person will be asked to become the mediator. Now, the first thing that person will do before actually being appointed to become the mediator is run a conflicts check. And that is to take a look to see if the potential mediator knows any of the people. Maybe they're related to somebody. Maybe their firm already represents one of the parties. That sort of thing. Those are conflicts. Some are more critical than others. Now, conflicts in mediation, in my opinion, are far less important than either in arbitration or litigation, because the mediator does not get to decide your case. The mediator really is just a way of getting to a resolution of the case. So the mediator can argue with the parties, can talk to them, can cajole and whatever, but ultimately the mediator doesn't get to decide how that case is settled, unlike in arbitration or in litigation. So in arbitration and litigation, if there's a conflict and there's a bias, that could be very detrimental to the outcome. In mediation, a bias is far less important because you can't really force the parties into a settlement that they don't want. Now, you still have to disclose those sorts of potential conflicts. So, and in some states there's actually laws about that. But so generally the potential mediator then is going to advise the parties, I'm on this committee or that committee with this attorney. I've had several cases with that attorney. I've been a mediator on cases with this party or that attorney or whatever. So then the parties get that disclosure and decide, is this really something that's important? Now, I would suggest that none of that really makes a big difference, because if, let's say, you're one of the parties and the brother-in-law of the other side's attorney is a potential mediator, but he's a really good mediator, so what if he's the brother-in-law? Now, that would be totally different in litigation or arbitration, but if that person can really get the parties to settle, that's really what you want. And so you would only knock somebody out on the basis of a conflict of interest if you think it's really going to affect the outcome of the case. But nevertheless, you're going to get the disclosures. You're going to decide whether that person is appropriate or not. If for some reason it turns out that potential mediator is not appropriate, then you go AAA will go to the next person and go through the same process and so forth. Now, when I'm the attorney for one of the parties to a mediation, and I get this list of potential mediators, I will probably know one or two or more of the people on this list. But there's going to be others that I don't know, I've never heard of. So what I will do is check with other people in my office, other attorneys, and ask, have you ever dealt with any of these people either in litigation, arbitration, or as a mediator? And particularly what I'm interested in is, has anybody ever had this person as their mediator in another case? And how has that gone? What was your impression? What did they do a good job? Did they, not that it necessarily had to settle, but were they doing the kind of stuff that really leads to a settlement? And I'll reach outside the office. I belong to some groups of attorneys that deal in construction, so I'll reach out to folks like that, and I'll call around. And if anybody's had some real experience with this person or that person, maybe I'll talk to them on the phone and try to get some feedback. So the due diligence part of this, I think, is important. You want to know as much as you can about these mediators so that you pick the right one. The selection of the mediator, I think, is very important if you really want to have that case settled. If you're there just to check off the box and you want to move on to the arbitration or the litigation case, then I guess it doesn't really matter. But if you're doing a good job for your client, you want that case to settle as soon as possible. And so you really want the best possible mediator who's going to get the job done. So now your mediator has been appointed and you're ready to start the process. So what's the first thing that happens? You don't just jump into the actual mediation session. You have a conference call with the parties. So when I'm the mediator, I will set up, as soon as I'm appointed, I'll set up a conference call with the attorneys. Now, the clients can be on the call if they want to, but that's extremely rare. So I want to talk to the attorneys about the procedures. I want to get an idea of how many issues are at stake. And we're going to talk about what I, as the mediator, am going to need to help me resolve this case. So I'm going to need information. Obviously, I'm coming into this at the start pretty cold. I don't know anything about the dispute. I don't know anything about the parties. And I need to know that kind of stuff. So what we're going to talk about on that initial conference call is, give me a little information. First of all, let's start out with a little thumbnail of what's the project about, what is the dispute about, who are these parties, are there other folks out there that may have some bearing on this. A lot of times in construction, the dispute is not just about two parties, it involves other parties too. If it's a big dispute, if there's a lot of money involved, there may be insurance companies that need to have input. And usually on a big construction case, if there's a big claim, the money is going to come not necessarily from the parties, but from the insurance carriers. So I want to know about how the insurance fits in. They're going to need to be at the table for this mediation if it's going to succeed. So I want to know who all the players are. Is it just the owner and the general contractor, or are there 2 or 3 subcontractors involved? Is the architect, does she play a role in this? Maybe somebody's going to point the finger at the architect or the engineer or what have you. So there may be a whole bunch of people that need to be in this mediation, and maybe they're not there yet. So we may decide early on that, hey, let's reach out. You guys need to invite other people, and maybe under their contract they have a way to do that. maybe sometimes not, but the threat of future litigation might bring them to the mediation table. So all of that stuff needs to be worked out, and we talk about all of that in the initial conference call. And obviously, if there's a lot of unknowns at this point, the initial conference call is going to be the first of possibly more than 2 or 3 or more conference calls as things move ahead and develop. I'm going to want to know if there's going to be experts involved. Sometimes the parties will have experts that intend to testify at an arbitration or court hearing. They may or may not show up at the mediation. Sometimes they're helpful in explaining things to me and certainly helpful in convincing the other side. So again, what you have to remember is that the purpose of the mediation is to settle the case. So if there's 2 parties involved, you don't need to convince me that you're right. You need to convince the other party that you're right. And if the more parties there are, so again, you're dealing with convincing whoever is on the other side or sides that you deserve money or what it is, whatever it is. And so an expert can be useful. So an expert can talk about why what this party did was really wrong, and maybe that client who's sitting when we actually have the mediation session, we're going to need people who actually are in a position to settle the case. So that may be the owner of the construction company. It may be the owner of the architectural firm. And it's probably going to involve the carriers, the insurance carriers, a claims person with authority to settle for that amount of money that's going to be in dispute. So these are the people that need to be convinced. And so an expert can really come in handy to present things that may open the eyes of these people. I often find that let's say the owner of the construction company really doesn't know all that much about the dispute. They've heard some stuff from their own people, the foreman and the superintendent, that kind of stuff, but it's been filtered through these people. So they don't have a good handle on how good the case on the other side is. And that's one of the dynamics that you have in a good mediation, where now all of a sudden the owner says, holy cow, this case is a lot worse than I've been led to believe. I'd better settle. And that's a good thing for the mediation. So the exchange of information, hearing from experts and other people at the mediation session is all good. So one of the issues we're going to be talking about at this initial conference call are position papers. So what are position papers? They are documents and related documents that the attorneys for each side prepares that lays out their case, their position, what it is that they want, why they're entitled to it, and it may include all kinds of exhibits and other information that's going to be helpful for me to understand their case. So I'm going to leave it up to the attorneys to decide what it is they want to put into this position paper, but they have to realize that I know next to nothing about the case, and I need to be brought up to speed beforehand. So I'm going to get this a couple of weeks out from the mediation session. I may have questions after I've received it, and I'll call the attorneys about their position paper and look for clarification and that sort of thing. But it's going to be up to the attorneys to decide how much information and what they need to put into this to help me to try to get the case resolved. Now, there's a couple of different types of position papers. And one is a private position paper, and that is where the party sends it only to me. The other side doesn't get it, so they don't see any of this stuff. And I look at it and so forth. The second type is the public position paper where it is shared with the other side. So everybody's on the same page. Everybody sees what everybody is sending me, what their position is, and so they understand, hopefully to a better degree than before, what it is the other side is saying about this particular matter. And then there's a hybrid version of this where there's a public position paper, just like before, but there's also a private document which is only sent to me. Now I like this one because the private paper, it's a letter or something like that, that gives me the insider baseball on what's going on. So there are things I would like to know that possibly isn't for general consumption here. So for instance, who is really the decision maker? Sometimes it's pretty obvious that, you know, this person is the sole owner of the firm and what have you. But sometimes it's a family-run business. So maybe it's a general contractor, the president of that corporation. His wife is the treasurer, but she's really in charge. She really makes the final decisions. And so I need to know that. So I'm going to be really looking at her and trying to get her convinced of how we can settle the case and get her feedback and that kind of stuff. So, you know, I don't want to be wasting my time with somebody that really doesn't have that final decision. Another instance is where there's a board. Let's say it's a church and there's a dozen people that show up representing, you know, being the party. And so who's who here? Is it the president of the board, the chairman, whatever? Usually on a board, there's going to be one or two or three people that really are the decision makers. And the attorney hopefully is going to know that. And I want that attorney to tell me who those people are, so again, that I can direct my most of my comments to those people and maybe take them aside if I need to do that later on. So that kind of stuff is things I need in that private paper. There's also one more thing, and that has to do with legal issues and other issues that the other side may not know about. So maybe this attorney here has identified a statute of limitations issue, and she believes that the other side has not seen this issue come up yet, but it may come up later. So she may want to point out to me, like, here's an issue, a potential issue, and here's some ways we plan to get around it. Here's some answers. Here's some responses to it. So that if I'm in my private caucus with the other side later on at the actual mediation session, and they say, hey, wait a minute, you know, we know that there's this, the other side has a statute of limitations problem, so we're just gonna, you know, stonewall them about this. So now hopefully I've got the information to say, well, wait a minute, you better think about that, because here's one or two points that you really need to think about before you take that position, and maybe you're not so solid after all. So if I get that kind of information from the first attorney, that may well help me to work with the parties later on. So I'm looking for as much information as I can, both shared information and confidential information that will help me to resolve the case. Now, another issue that does come up is who needs to be at the mediation. Obviously, I've talked about the decision makers, and so those decision makers, whoever has the ultimate authority to settle the case, has to be there. I don't want them back at the office and they send the vice president who, you know, looks like they may have authority, but then they have to pick up the phone and get the president on the line to authorize a settlement. That's bad. That's not a good idea. Where this really becomes a problem is with insurance carriers. So if there's going to be insurance that is going to fund a large part of whatever settlement comes about, I need that claims representative at the mediation session so that she can hear what's being said. Maybe she's heard from the attorney that, you know, this case is worth $100,000, so she has $100,000 in authority. But it turns out their side, their case is really far worse than that. So they may have to cough up $500,000. So, you know, even if she walks in the door with less authority, if she now hears good, solid, you know, stuff from experts and from this party, and she can kind of look at the, you know, the opponent here and decide, you know, this woman is really very credible and she's going to make a great witness and we're going to get murdered at a trial or an arbitration. So if she's there, she can make those sorts of assessments, and if she has to call the home office, it's fine. But you know, it's going to be a lot easier to get that insurance representative to cough up whatever money they need to if they hear this, if they have firsthand knowledge of what's going on. So decision makers need to be there. Now, one of the things I really want, in addition to the position papers, or probably as part of the position papers, is a more detailed breakdown of the claim. And the other side is going to want this too. And basically that's a detailed listing of each item of damages. What is the item? What is the cost to repair it if it's an estimate, or how much have you paid to fix it if that work has already been done? And that really outlines what the claim is. So not only do I need to see it, but generally the other side needs that as well, because they haven't seen that. Now in some cases they'll know what those items are, but I find in many cases the other side is pretty much in the dark as to the real details of what that claim is. So again, that along with the position paper is something I'm going to want from each of the parties. And often what the parties want is to be able to respond to that with a responsive position paper. So let's say the owner has claimed a whole bunch of items. The roof leaks, the windows leak, and maybe they've repaired the windows but not the roof. And here's our costs and our estimates and so forth. Now the general contractor is going to want to be able to see this document and to respond to it and say, well, look, we didn't install the windows. That was, the owner hired a separate contractor to do that, or whatever reason. There may be some other reasons why they feel they're not responsible, or the costs are way out of line, and there are reasons why this claim has been inflated and whatnot. So each side then will have a chance to kind of pull this together, because when we get to the actual mediation session, I want at least the issues to be known. They may not be resolved, but everybody should understand what the other party's position is and what they're likely to be presenting at an arbitration hearing or at a trial at court down the road. So this gives everybody a chance to kind of get on the same page, understand the situation, and allow me then to try to talk to each side and get the case resolved. One of the things I find is also very useful is I will tell the parties at this initial conference call that what I would like is the claimant's attorney to draft a settlement agreement. And I want this done prior to the mediation session. So, maybe it's not drafted until after some of these position papers are done and the claims are all in. But I need, and this is really very helpful for the parties, to have a settlement agreement ready to go. The dollars are left blank, and there's maybe some blanks for other terms. It's best to have it probably on a laptop where all the stuff you need, the boilerplate terms and things are in there. But it's also useful so that the parties can think about what they're really going to need. So the owner may want to have language in there about releasing mechanics liens and what about future repairs and guarantees. How are all those affected? And then I want that whoever's drafting that to exchange it with the attorney for the other side and work back and forth so we have at least the outline, a very good outline of a settlement agreement, and then assuming the case settles at the mediation session, we just have to fill in a few blanks. And what that saves is sometimes if you don't have this, you get to a mediation where it looks like it's settled, everybody sort of agrees on terms, and the attorneys say, well, we're going to go back to our office and we'll exchange this. And the thing blows up. Or they'll spend an hour or two writing on their yellow legal pads in handwriting what their terms are, and then one of the sides remembers later on that, gee, we've forgotten this important thing to put in here. It wasn't necessarily part of anything in dispute, but there's some legality because the bank needs a release or somebody else needs a piece of paper that in the heat of the moment they just don't think about. So get a settlement agreement pulled together with all that kind of stuff so that they've had a chance to think about it, and then you can massage that at the end of the mediation with the real settlement. So I think that's very important to do. Now, one of the ways that mediations are different than arbitrations is that in mediation, ex-parte communications are allowed. That's where one party talks to the mediator without the presence of the other party. Absolutely not permitted in arbitration or in court. You can't talk to the judge without the other party present. So these ex-parte communications are generally done just before the mediation, after the position papers are in. So I may have questions about what did you mean by this statement in your position paper, or just clarifications of things in the position paper. On bigger cases, I may have a series of conversations with the various attorneys at different times as things develop, because there's maybe a series of conference calls, a series of submissions, and what have you. So the point of these, again, is to give me, as your mediator, information that is going to be helpful for me to help resolve the case. So sometimes the attorneys really don't want me talking to the parties privately. And that will happen at the actual mediation. And I will generally ask the attorneys at the start of that I may want to talk to your parties in private. And there may be reasons for that. But I do get pushback from attorneys that want to keep control over that client. Ultimately, it's going to be up to the attorneys whether they let me talk to their clients. I think that's a disservice to their client if they take that position, but it does happen. I find it useful. I need as much flexibility as possible to talk to this person or that person or some combination of these people. I may want to bring the experts together and into a separate room and have them talk by themselves. Whatever is necessary to make this case settle. And that's my job. My client really in this mediation is the settlement. So I want to have a settlement reached by the parties And that's my job to get to that point. So the clients, both before the mediation session and during the mediation session, the attorneys, especially the ones that haven't done a lot of mediations, they can be an obstacle. I really want the attorneys as my allies and help me convince their client of the facts of life. You know, it's going to be, if this doesn't settle today, then the cash register really starts ringing along here. It's going to get really expensive. You're going to have a lot of discovery and this and that and the next thing. And so I'm going to be talking to their client, you know, aiming my conversation at the client, but the attorney's going to be sitting there in most cases. And I want him to help me with this. Now, sometimes the attorneys will really push back and say, you know, it's not going to cost $100,000 in attorney's fees. I can do it for $10,000 or, you know, something like that. Even though I know that's totally out of bounds, or this attorney really doesn't know what he's talking about, which also does happen. So again, I'm looking for as much help as I can in the mediation, and you know, I hope to get a lot of help from the attorneys as my ally in trying to get the case resolved. Okay, now we're at the big mediation. The big day has come. Everybody's shown up at this conference room. And the first thing I like to do in most cases is to get everybody together into the biggest one of these conference rooms that we have. Introduce everybody. Now, it's likely that, you know, a lot of them are going to know each other, but there's always a few that haven't met everybody. And then I'm going to talk about who I am. I'll introduce myself, and I'll talk about the process. Many of these people have never been in a mediation. They don't know the difference between mediation, arbitration, and so forth. So I'm going to talk about this process to them. And we're talking about the clients here mostly. And I'm going to tell them that this is a confidential process, and what they tell me in private is not going to go to the other side unless you authorize me to do that. I'm also going to remind everybody that this is in the nature of a settlement conference, and that has legal meaning, so that anything that's said during this mediation can't be used in any other proceeding, in any arbitration or court. So you're not going to wind up in court later, you know, a year down the road, and somebody saying, hey, this person said this at the mediation. That's not going to happen. And any judge or arbitrator is quickly going to put the kibosh on that. So the idea of that is to kind of let the parties open up a little bit. Now, you know, as a practical matter, they're not going to totally open up, but hopefully it'll be a lot more open than it would be otherwise. So my job at this mediation is to settle the case. That's the only job I have. And so my client is the settlement. So I'm not the attorney for this side or that side. I don't give legal advice. I don't tell you what to do. But I may try to convince the parties. And generally this is going to be later on when we're in our private sessions. But at the initial session where everybody's there, after I've made my opening remarks, I'm going to invite each party, generally the attorneys, to make a presentation. And I've probably talked about this to the attorneys a little bit beforehand so that they're ready for this. But I want them to present their case as best as they can, you know, within a short period of time. And maybe that's 5 minutes, maybe it's an hour. And the attorney can talk, the client can talk, whatever that attorney wants to do to present that case. This is very informal, and so it's more of a discussion. But here's, you know, and generally the less formal, the less legal it is, the better of an impression it makes. I mean, this is about convincing the other side that you are right and you are entitled to money, or whatever your position is. And I'm not the one who needs to be convinced. You need to convince the other side who's sitting across the table. Now, sometimes I will have talked to the attorneys, and the attorney's going to tell me, this is ahead of time now, the attorney's going to tell me these parties hate each other. There's absolutely no way they should be in the same room. And this happens more than you think it might. So there's been really bad feelings leading up to this mediation. And so we don't have a joint session. So we'll start out with separate sessions, and I'll meet with the parties. But if that's not the case, and generally in situations where you've got a general contractor and a subcontractor, business people that may want to actually hopefully continue that business relationship after this is over, they're going to be professional, and we're not going to have that type of issue. So everybody's going to present what they want to present, have it out in the open, so that, again, everybody needs to be on the same page. They need to know what the issues are, what's being asked, what the counter issues are, what the responses are, and so forth. And we'll have a back and forth. So when the parties are done, maybe the client over here is going to have a question for this side over here. Maybe the client is going to say, hey, wait a minute, you mentioned that we had this meeting and I said this, but that didn't even happen. I wasn't even there. That was, somebody else may have said that. So they'll try to kind of come together on the factual parts of this, and again, to try to get the facts as close to reality as possible. And we may have the experts talk. We may have whatever it is. So at some point, when we've kind of exhausted all of this, and it may be 10 minutes into it, it may be 2 or 3 hours into it, then I'm going to say, okay, look, I think we're done with this phase of the mediation. So let's everybody go to your rooms, and I'm going to come in and talk to each of you separately. So then I begin my shuttle diplomacy. These are caucuses, and I'm going to talk to this party for a certain amount of time. Then I'll go to the other room and talk to that party, and basically kind of go back and forth. And we'll talk about the case. We'll talk about whatever needs to be discussed. And each mediation is different in that regard. I may talk to the first party for half an hour or an hour. So I'm going to tell them that, don't stick around, have some coffee, but don't count on me being back in 2 minutes. It may be a longer time. I may be back in 2 minutes. I may come back with, here's a question about a major issue that we haven't discussed yet. What about this? And we'll have a discussion. I'll go back to the first party. And so it's a back and forth. Now, at some point in this whole process, we've kind of exhausted all of the factual questions that may be out there, and either the parties will decide, okay, this is clear, or it's just not going to get cleared up today, whatever. And at some point we get down to dollars. One of the things that I really start talking to the parties separately about, when we get to the dollars, it's sort of near the end of this whole process. We've now talked about the facts and the background and all that kind of stuff. And hopefully people are on the same page as to what happened and all the factual issues that may be out there, and possibly legal issues that the parties have discussed with me. But now, at some point, most mediations are going to settle based on dollars being paid by one party to the other. And that may involve the insurance people and so forth. So there's going to be a discussion now about the costs moving forward. So I'm going to see if each of these parties has a good handle on the costs. And we're going to do some calculations. And sometimes this is a real eye-opener for the parties. So for instance, you've got a $500,000 claim, and if this doesn't settle, you're going to wind up in arbitration. So I'm going to ask, maybe I'll ask the attorney, so what do you anticipate in terms of the number of days of hearings? And he may say, oh, this is a simple case, it's 3 days. Well, probably he's way off the mark here. So if he says 3 days, it's probably 5 days or 6 days or 7 days or something like that. So I will ask, okay, so you're going to have a filing fee with the association, and you're going to be paying by the hour for the arbitrator. And he's got preliminary time in there, so that's maybe 20 hours of preliminary time. You've got 7 days of hearings. You've got another 20 hours of study time and preparation. And so maybe you're at 150 hours at this point of arbitrator time, and at $500-600 an hour. So now you're talking, $20,000, $30,000, $40,000 per side, just for that. You've got at least one expert, maybe two experts, and so that cost might be 10, 50, 100,000, several hundred thousand, depending on the amount of work that you're going to ask that expert to do. You're going to have the attorney, and Mr. Attorney, how much are you going to be charging for this all the way through the arbitration? Generally, I get a lowball number. And what I hear more than anything else is the attorney tells me, well, I've already done all the work. Absolutely not true. That's impossible. You can't possibly have done all the work at this point to be ready to go to an arbitration hearing. So I'm going to try to inject a little bit of reality in here. So maybe if it really is fairly simple, maybe you've got $100,000 or $150,000 in costs going through the end of that arbitration. Maybe it's only $100,000. Maybe it's $400,000. It could well exceed the amount that's at issue. So I'm going to ask the party then, okay, now whatever that number is, and you decide what number you want to use. Now subtract that from the amount of the claim that you've got. So if you have a $500,000 claim and you are looking at $150,000 in costs getting to the end of that. So if you paid $350,000 today, or if you received $350,000 today, that would be as good as getting $500,000 at the end of this process. Generally, they'll see that makes sense. Then there's the unknown of, okay, even though an arbitration is final, let's assume you win the arbitration, that it's final. That doesn't mean that a party can't try to appeal that award, and they sometimes do. So it goes back to a trial court somewhere, and there's a fairly short process, but it's going to involve a bunch more money. And then if they don't like that, they can take it up to the appellate court. And so you've added another year maybe to collecting your money, and have paid another $50,000, $100,000 in fees out to your attorneys and whatever else you may have. So you got to factor all that in. The next factor is, what are your chances of winning? Are you convinced? Is your attorney going to guarantee the outcome? Is your attorney going to guarantee that you're going to win? Well, no attorney in his right mind is going to guarantee that you're going to win. You may think you've got the best case in the world, but what that means, it's maybe 90 or 95% chance. You may always have a rogue arbitrator. You may always have some judge that really doesn't know anything. And I've seen those kind of folks, arbitrators and judges, that are, just way off the charts over here. And so the best case in the world doesn't get you the right outcome. So there is a chance that you may lose. So you've got to discount that money by your chances of not prevailing. So maybe on that $500,000 claim you've got, a $250,000 settlement is actually a pretty decent deal, even assuming you could win the case. So we run through those kind of numbers. Another way to look at it is, okay, what are your chances of winning everything? What are your chances of losing everything? You could easily lose and get nothing and have paid $150,000 in fees and costs. And somewhere in between there, you can make an assessment that, okay, here is sort of the probable outcome. And we can put a number on that. And going through all those numbers with the parties, I think will help them put aside the emotions and put a realistic value on the settlement. And we do the same thing with the other sides, talk to the insurance folks, and hopefully those numbers are going to wind up becoming very close together. And a lot of times I see that now, instead of a $500,000 spread, we're down to $50,000 or $30,000 or something like that. And then we try to get that last little piece, and generally with a little bit more back and forth, we can come to a settlement amount. Now, hopefully the attorneys have prepared a draft settlement agreement like I suggested earlier. And if that's the case, we fill in a couple of numbers, we get everybody to sign it, and they go on their way. If they haven't done that, it becomes much more difficult, because now either somebody is taking out a pad of legal paper and starting to write all this out, or they're trying to do it on their laptop, and maybe they've forgotten something that this person over here is going to need a release of a lien or something like that. But and sometimes I'll have the attorneys tell me, okay, we trust each other, we're done, we're going to go back to our offices and put something together, and the parties will sign the settlement in a week or two. It's taking a big risk. If they really want to do it, okay, but I really strongly advise them to wait and finish up this deal. Let's get a settlement agreement walking out the door, and then it really is final. It's not settled until you've signed that settlement agreement, whatever it is. And if that document is signed, then I've done my job.